A very good morning to all my dear students. Today we are going to discuss about the concept of appeals from original decrees. But before starting with this, I just want to recapitulate what we have discussed in my last lecture, as the same would be as the same would help you understand about this topic as well. My dear students, the relevant word with which this particular topic needs to be started is that we must first define the word appeal. As you all are aware that the word appeal has not been defined in the Code of Civil Procedure 1908. But there are certain expressions which have already been defined under section 2 of the Code of Civil Procedure, such as the word decree, judgment, order, so on and so forth. But the legislature did not felt it relevant to define the word appeal under the said section of the Code of Civil Procedure. As per Camber's Law Dictionary, 21st edition, appeal has been defined as the judicial examination of the decision by the higher court of the decision of an inferior court, meaning thereby appeal is a proceedings by which the defeated party approaches a higher court or court to have the decision of a lower authority or court reversed. Further, we had also discussed the case of Nagendra Nath Day versus Suresh Chandra Day, wherein it was observed that an appeal is a removal of a cause from an inferior court to a superior court for the purpose of testing the soundness of the decision of the inferior court, meaning thereby it is a remedy provided by law for getting the decree of the lower court set aside. In other words, it is a complaint made to the higher court that a decree passed by the lower court is unsound and wrong. Now, the relevant now in this background, we have to start with the today's topic. Any person who feels aggrieved by any decree or order passed by the court may prefer an appeal in superior court if an appeal is provided against that decree or order. From this, it may be inferred that the appeal is a statutory remedy. If the statute does not provide this remedy, then the aggrieved party cannot approach the higher court against the impugned order passed by the lower court. The relevant sections which have to be read for the better understanding of this topic, that is appeals from original decree, are from section 96 to section 112, and relevant orders which needs to be read for the appeals are order 41 to 45. wherein the first appeal has been given from section 96 to 99A and order 41. Now, we will straight away come to the point that is with regard to appeal from original decree. The relevant section for this is the section 96 of the Code of Civil Procedure, which confers a right to appeal. Section 96 clause 1 provides that first appeal shall lie from every decree passed by any court exercising original jurisdiction to the court authorized to hear appeals from the decision of such court. Meaning thereby an appeal can lie from every decree, and it must lie to the higher court and not to the lower court against the decision passed by the trial court in this civil suit. Further, 96 clause 2 of the Code of Civil Procedure provides that an appeal may lie from original decree passed ex parte. 96 clause 3 provides that no appeal can lie from a consent decree, meaning thereby if both the plaintiff and the defendant to the suit enters into a compromise before the trial court in the said civil suit, then that compromise would tantamount to a decree, and as both of them have consented, so later on both of them cannot approach the higher court against that decree, because that decree attains finality in the eye of law. There is 96 clause 4 which has been inserted or amended by 1999 amendment. This amendment came into force in the year 1999, wherein it is laid down that no appeal shall lie from a subject matter of the suit which does not exceed 10,000 rupees except on a question of law, meaning thereby an appeal cannot lie against the decree amounting to rupees 10,000, provided an appeal may lie against such a decision only on the question of law and not on question of fact. Next. Now, what are the conditions for filing an appeal against what are the grounds on which this appeal from original decree may lie? Number one, the subject matter of the appeal must be a decree, meaning thereby it would satisfy the requirements as laid down under section 2 clause 2 of the CPC, which defines decree. Second, party appealing must have adversely affected by such determination, meaning thereby an aggrieved party may approach the higher court, even though that party was not made party before the trial court. If the stranger, meaning thereby, if the stranger who is not a party before the trial court may also approach the higher court, provided he will satisfy the court that such a decree is prejudicing or shall prejudice him. and indirectly applying upon him. Next, who may file an appeal? Generally, a party to the suit adversely affected by the decree or his representative in interest may file an appeal. As far as the definition of representative or the legal representative is concerned, or the law relating to legal representative is concerned, the same is defined under the section 2 as well as the relevant provision under section 50 of the Code of Civil Procedure. Further, there is an exception to this general rule, wherein we may say that the stranger may file an appeal also against that such decree only with the leave of the court, meaning thereby with the permission of the court, a stranger can also file an appeal against a decree which is adversely affecting him. Next. What are the considerations to be kept in mind while giving the permission to the stranger for filing an appeal against a decree by the court of law? So these are the considerations to be kept in mind by the court of law while giving permission to the stranger for filing an appeal against that decree. So these considerations are: number one, the decree passed by the court is adversely affects the aggrieved party. Second, it is prejudicially affected by the decree. And third, he is bound by that decree. Number one, adversely affected by the decree. Number two, prejudicially affected by the decree. And number three, he is bound by the decree. If these considerations are there in the appeal pending before the higher court, then the higher court may allow the stranger to challenge the particular decree. Generally, a decision cannot be said to be adversely affect a person unless it will operate as a res judicata against him in any future suit. Now, here I just want to recapitulate the law relating to the res judicata. My dear students, as you all are aware, res judicata means a thing which has already been decided, meaning thereby, if a particular cause has already been decided, then re-agitation of the same cause cannot be allowed in the further court. Next, who cannot appeal? Meaning thereby, whether the right to appeal can be waived. Answer is waiver of right, meaning thereby if the party agrees not to appeal or waives his right to file an appeal, will be bound by an agreement if otherwise such agreement is valid. Answer is yes, provided the said agreement must be valid in the eye of law, meaning thereby it satisfies all the requirements as laid down under section 10 of the Contract Act, or the essentials of valid agreement. Now, the question is whether an appeal can lie against a preliminary decree. Answer is yes, a preliminary decree is as much a final decree. In fact, a final decree is but a machinery for the implementation of the final decree, meaning thereby Section 97 provides that if the plaintiff fails to file an appeal against a preliminary decree, then it precludes the aggrieved party from challenging the final decree. So the expressions preliminary decree, my dear students, and the expression final decree has also been defined under Section 2, Clause 2 of the Code of Civil Procedure. Now, another question which needs to be taken into consideration over here is that whether can an appeal lie against a dead person? Answer is no. No appeal can be instituted against a dead person. Such an appeal, therefore, can be regarded as a stillborn appeal. In such cases, an application can be made for the substitution of LRs of the deceased respondent who died prior to the filing of the appeal. So my dear students, the law is that you have to file an application for the substitution of LR in place of the deceased person. And my dear students, as you all are aware that the said application would be filed under Order 1 Rule 10 of the Code of Civil Procedure. Sorry, Order 22 of the CPC. Now, what are the requirements for filing an appeal from an original decree? The requirements are: it must be in the form of memorandum. Further, it must be signed by the appellant or his pleader. Number third, it must be presented to the court or to such officer as authorized. Number four, it must be accompanied by the certified copy of the judgment. Now, I just want to apprise you about the difference between an appeal and a memorandum of appeal. As you all are aware that an appeal under Order 41 Rule 1 CPC provides that appeal must be filed in the form of memorandum of appeal. So, one must know the difference between the expressions of appeal as well as memorandum of appeal. Appeal is a judicial examination by a higher court of the decision of a lower court, whereas the memorandum of appeal contains the ground on which the judicial examination is invited in respect of the appeal pending before the higher, in respect of the appeal which is going to be filed by the appellant against the impugned order of the trial court. So this is all about today's lecture. But before finishing the today's lecture, I just want to again apprise you with the points which I have dealt in this particular lecture. We have already discussed about the meaning of the appeal. Thereafter, we have also discussed about the essentials of appeal. Thereafter, we had also discussed about the right of appeal and also about Section 96 of the Code of Civil Procedure. Thereafter, we had also discussed about who may appeal or who may file an appeal. Thereafter, we had also discussed about whether an appeal can lie against an ex parte decree. Further, we had also discussed about no appeal against consent decree. Thereafter, we had also discussed about appeal against preliminary decree and final decree. Thereafter, we had also discussed about appeal against dead person. Thereafter, we have discussed about the requirements for filing an appeal and also the difference between appeal and memorandum of appeal. So this is all about today's lecture, my dear students. Hope you have learned a lot from this lecture. In case you have any query, then you may write it to me at my email ID, that is rahularora.gn@jagannath.org. But before parting with today's topic, I just want to apprise you with my new topic, which I am going to take in my next lecture. And my dear students, my next lecture would be on appeal from original decree, wherein we are going to discuss about the form of appeal, forum of appeal, valuation in appeal, condonation of delay in filing an appeal, whether steps involved in hearing of an appeal, and also about the stay of proceedings in respect of an appeal, and the procedure to be taken by the court of law at the hearing of an appeal. So this is all about today's lecture. Thank you very much. We'll meet you soon in my next lecture. Till then, stay home, Stay safe and stay healthy. Thank you very much again.